Hello everyone, this is Dhanashri Chougale and you're watching Ganga Education. Welcome back to my channel. On this channel, you will get information regarding law and competitive examination related to law. So subscribe my channel and hit on a bell icon so that you can get information regarding upcoming videos. In this video, we are going to solve a question paper of Maharashtra Civil Judge Junior Division and Judicial Magistrate of First Class Preliminary Examination held in 2015. This video series will be in 4 parts. We will discuss 25 questions in each video. For this video, we will solve from question number 1 to question number 25. So without further delay, let's get started. This is question paper of Judicial Magistrate of First Class Civil Judge Junior Division Preliminary Examination held in 2015, and this is set A. We have already discussed the instruction for candidate while discussing 2011 question paper. So we are not going to discuss it in detail here. Let's jump on question number 1. Question number 1. When did the Code of Criminal Procedure 1973 come into force? Option number 1, 26th January 1973. Option number 2, 1st April 1974. Option number 3, 1st April 1973. Option number 4, 30th June 1976. And the correct answer is option number 2, that is 1st April 1974. Now question number 2. How can an arrest be made by a police officer? A. By handcuffing the person to be arrested. B. By touching the body or giving oral intimation of arrest in case of a woman. C. By confining the person to be arrested. D. By all of the above. And option number 1, only A. Option number 2, only B. Option number 3, both B and C. And option number 4, only D. And the correct answer is option number 4, only D, that is all of the above. Now question number 3. The Chief Judicial Magistrate is empowered to impose a sentence of imprisonment. Option number 1, not exceeding 10 years. Option number 2, not exceeding 5 years. Option number 3, not exceeding 7 years. Option number 4, none of the above. And the correct answer is option number 3, not exceeding 7 years. Now question number 4. Right of the accused to be produced before a magistrate within 24 hours is a, option number 1, fundamental right. Option number 2, civil right. Option number 3, statutory right. Option number 4, human right. And the correct answer is option number 1, fundamental right. Now question number 5. When information relating to the commission of cognizable offence is received by the officer in charge of a police station. Option number 1, he can make inquiry and then decide whether to register an first information report or not. Option number 2, he has to register an first information report as a rule. Option number 3, he can refuse to register an first information report. Option number 4, he can direct the informant to seek direction from the magistrate. And the correct answer is option number 2, that he has to register an first information report as a rule. Now question number 6. Which of the following is a correct statement? Option number 1, Court of Session can take cognizance of any case triable by it. Option number 2, Court of Session can take cognizance when complaint is filed before it. Option number 3, Court of Session can take cognizance when the High Court directs. Option number 4, Court of Session cannot take cognizance unless the case has been committed to it by the magistrate. And the correct answer is option number 4, that is the Court of Session cannot take cognizance unless the case has been committed to it by the magistrate. Now question number 7. Statement of the accused under section 313 of the Criminal Procedure Code is option number 1, a mere statement of the accused to be used to know his defense. Option number 2, of no use for the prosecution in the trial. Option number 3, also part of the evidence in the trial. Option number 4, not an evidence but can be considered by the court as a matter before it. And the correct answer is option number 4, not an evidence but can be considered by the court as a matter before it. Now question number 8. In camera proceeding means option number 1, a proceeding recorded by video camera. Option number 2, a proceeding held in private place or premises. Option number 3, a proceeding during which the public in general or particular is not allowed to watch. Option number 4, a proceeding conducted in a closed room secretly. And the correct answer is option number 3, a proceeding during which the public in general or particular is not allowed to watch. Now question number 9. A judicial magistrate of first class can order payment as compensation to the person who sustained loss or injury by reason of the act for which the accused has been convicted. Option number 1, any reasonable amount to recompense the loss. Option number 2, any amount not more than rupees 5,000. Option number 3, any amount when fine is not a part of the sentence. Option number 4, any amount that the accused offers in order to get soft sentence. And the correct answer is option number 3, any amount when fine is not a part of the sentence. Now question number 10. The jurisdiction and power of judicial magistrate. Option number 1, extends throughout the taluka wherein he is posted. Option number 2, extends throughout the district where he is posted. Option number 3, is coextensive with the area of the police station within his local jurisdiction. Option number 4, extend to the area as the district judge may define by special order. And the correct answer is option number 2, extends throughout the district where he is posted. Question number 11. From an order of an acquittal by the magistrate in a complaint case, appeal lies with the option number 1, Court of Session. Option number 2, Chief Judicial Magistrate. Option number 3, High Court. Option number 4, District Magistrate. And the correct answer is option number 3, High Court. Now question number 12. Period of limitation for taking cognizance if an offence is punishable with a fine only is option number 1, 1 year. Option number 2, 6 months. Option number 3, 3 years. Option number 4, no limitation. And the correct answer is option number 2, 6 months. Now question number 13. In a bailable offence, the accused can claim his release on bail. Option number 1, not as a right, since the court can refuse his release for special reason. Option number 2, after hearing the complaint of the public prosecutor. Option number 3, as a matter of right. Option number 4, but it is the judicial discretion of the court to grant or not to grant bail. And the correct answer is option number 3, as a matter of right. Now question number 14. Legal representative means option number 1, sons and daughters of the deceased person. Option number 2, authorized agent or the representative of the deceased. Option number 3, class 1 heirs of the deceased. Option number 4, any person who in law represents the estate of the deceased. And the correct answer is option number 4, any person who is in law represents the estate of the deceased. Now question number 15. First date of hearing of the suit is option number 1, the date for framing of issues. Option number 2, the date on which the defendant is summoned to appear. Option number 3, the date fixed for filing written statement. Option number 4, the date on which argument on merit is to be heard. And the correct answer is option number 1, that is the date for framing of issue. Now question number 16. Precept is an order issued by the court which passed the decree and addressed to? Option number 1, the collector to effect partition of property. Option number 2, another court to arrest the judgment debtor residing in the jurisdiction of that court. Option number 3, the other court to attach the property of the judgment debtor specified in the precept which is in the jurisdiction of that court. Option number 4, the revenue court to sell the property attached by the court. And the correct answer is option number 3, the other court to attach the property to the judgment debtor specified in the precept which is in the jurisdiction of that court. Now question number 17. Defendant can be arrested before judgment in a suit for option number 1, partition. Option number 2, possession of immovable property. Option number 3, recovery of money compensation. Option number 4, specific performance of contract to sale of immovable property. And the correct answer is option number 3, recovery of money compensation. Now question number 18. Executing court has to decide under section 47 of the Civil Procedure Code. Option number 1, all the questions raised between the parties to the suit. Option number 2, all the questions between the parties to the suit relating to execution, discharge and satisfaction of the decree. Option number 3, all the questions between the parties to the suit and the third party. Option number 4, all the questions between the parties except those relating to delivery of property to the auction purchaser. And the correct answer is option number 2, all the questions between the parties to the suit relating to execution, discharge and satisfaction of the decree. Now question number 19. Which of the following cannot be attached in execution of decree? Option number 1, government, securities or bond. Option number 2, undivided interest or share in the immovable property. Option number 3, whole of the salary. Option number 4, mortgaged property. And the correct answer is option number 3, whole of the salary. Now question number 20. Service of the summons or notice by advertisement in a newspaper is option number 1, an alternate mode of service. Option number 2, permissible when defendant resides at the distant place. Option number 3, permissible when plaintiff is not aware of the address of the defendant. Option number 4, a substituted service when the court is satisfied that the defendant is avoiding service or he cannot be served in the ordinary way. And the correct answer is option number 4, a substituted service when the court is satisfied that the defendant is avoiding service or he cannot be served in the ordinary way. Now question number 21. Inherent powers of the civil court are option number 1, complementary to the power specifically conferred to be used when required to render justice. Option number 2, the powers conferred by the statute. Option number 3, the powers which are not limited by statutory provisions. Option number 4, plenary powers of the court. And the correct answer is option number 1, complementary to the power specifically conferred to be used when required to render justice. Question number 22 has been removed from this question paper due to typing mistake. Here the criminal procedure code is mentioned in this question, but it is not a criminal procedure, it is a civil procedure. So this question has been removed. Now question number 23. Suit is liable to be dismissed when there is option number 1, misjoinder of parties. Option number 2, non-joinder of proper parties. Option number 3, non-joinders of necessary party. Option number 4, misjoinder of cause of action. And the correct answer is option number 3, non-joinder of necessary party. Now question number 24. Defendant can set up counterclaim against the claim of plaintiff. Option number 1, when defendant has a cause of action occurred before filing of the suit. Option number 2, when defendant has a cause of action occurring against the plaintiff either before or after filing of the suit. Option number 3, when defendant has a cause of action occurred against plaintiff during trial. Option number 4, in all the circumstances mentioned above. And the correct answer is option number 2, when defendant has a cause of action occurring against the plaintiff either before or after filing of the suit. Now question number 25. Actio personalize moritur cum persona means option number 1, personal action does not die with the person. Option number 2, personal action varies from person to person. Option number 3, trivial actions should not be carried to the courts. And option number 4, personal action dies with the person. And the correct answer is option number 4, personal action dies with the person. That's it for this video. In upcoming videos, we will solve remaining 75 questions. And again, we have also solved question paper of 2011 to 2014. The links are provided in description box. Please go through those links also. Thank you for listening.